Hello, I'm Neil Whelan and welcome to the Wesleyan Podcast. In this episode, Laura Weaver from our dental marketing team talks to Wesleyan Financial Services financial consultant Bal Tandy about the financial concerns of associate dentists. In particular, the employment statuses of associates and the potential impacts for them and principals and what needs to happen next. But first up, Laura asks Bal about locum cover and its importance to dentists.
Yeah, locum cover is simply insurance that's taken in the event of a dentist not being able to do their work or due to a sickness or an accident or an injury. In summary, it covers the cost of a substitute being paid to carry out that dentist role.
Okay, so would this be something for an associate dentist to consider then, seeing as they're self-employed?
Yeah, you're right. It's very important. The majority of associates are self-employed professionals. One of the key indicators of self-employment is, the subject of substitution, which means, whether a dentist can demonstrate if they're able to recruit and pay for a locum or a replacement dentist if they're not able to do their role themselves. Up until now, the associates have been covered, which has been, fairly unique to dentistry. As long as associates had and used standard forms of agreement, such as from the BDA or the DPA, and adhered to them, these agreements pretty much offered protection when assessing, their income as trading income as opposed to employed income. But that's all due to change. On the 6th of September this year, the guidance for dentists is to be withdrawn. And come 6th of April 2023, the status of new and existing contracts or dental contracts should follow the CEST or the Czech Employment Status for Tax rules. Basically, this doesn't pick on dentists unfairly. What this actually does is that it brings dentists in line with the rest of the working populations rather than, them being assessed by exception, which has pretty much been the case in the past. What this means in practice is that the HMRC will look for evidence to ensure that the contract that they've set up by, between themselves and the principal is working in practice. So whether it's a sole trader, a limited company, or a corporate outfit. Beforehand, it could have been, a short conversation. The agreement's been sitting in a desk somewhere gathering dust. It's now going to be based on individual circumstances and local arrangements, as opposed to just an agreement that's just written in paper and put away, to be honest.
Okay, that's really interesting. So in terms of the locum clause, I guess that's not really just up to the associate to enforce, is it? It'd be something that the principals would need to consider themselves.
Definitely. The principal or the engager who enforces that locum clause will be the person or the organisation who pays the salary. So for principals, that means that if it's not carried out in practice, the CEST test will almost certainly catch them out. What this means is that the HMRC will interview the principals and the associates separately. And if there are found to be any anomalies, then, the principal could find themselves in hot water. How so? Well, one example is that the impact that national insurance will have. So, when you look at the average associate in the UK, currently, the employer contributions, NI contributions, can amount to something like £10,500 per associate. And if the HMRC are not happy with the way that these working arrangements are put into practice, they can backdate this liability by 6 years. So, for example, a principal who runs a practice with 4 associates could ultimately deal with an HMRC liability that could range from £42,000 for one associate if they were backdated to 6 years, up to £252,000 for all 4 associates should the HMRC decide to backdate this liability, which they can do.
Okay, so that's very concerning then for the principal dentists. What about the associates? Are there any kind of negative implications of them being considered employed, maybe perhaps from a tax perspective or something?
I guess that for me, the biggest single implication is that they would see their pay reduced significantly as an employee rather than being self-employed and having that flexibility that they have at the moment. And that's because of the additional costs that the principal or the practice owner will have to bear as an employer. Would have to be, I mean, as an employer, they'd have to meet that cost from somewhere. This could also mean that if the HMRC sees a mismatch between a standard associate agreement that's not being used in practice and it's not a live working document, then their employment status comes into question. And you've only got to look at the recent Uber case that has really been an example of this. As I mentioned already, many associate dentists have relied on their income as trading income and not employment income. So in this case, there would be no pay as you earn due, and the relevant NI contributions would already be paid for. But the removal of these guidelines in just 18 months' time means that if the CESS test is not met and dentists do not carry out other work relating to these standard agreements that have been put in place, such as paying for their share of the lab fees or having locum cover in place, then there could be harsher penalties, especially as HMRC now begin to bring the dental world under the spotlight.
Okay, that's really interesting. So I guess, are there any other kind of like knock-on effects that we haven't really discussed at the moment? It could be for either the associates or the principals that it's just really worth thinking about.
Apart from what we already mentioned about the national insurance impact, the other impact for the principal to think about is the enforcement of the locum clause. And understandably, they could potentially risk losing a good associate. I guess one way of looking at that, this regretted loss, would be to up the actual UDA per unit to perhaps 10 or 15 pence per UDA to each associate. So an associate, for example, doing 6,000 UDAs a year, that would mean an extra £600 to £900 by increasing that unit. But this could or would easily pay for the locum cover if it was arranged through Wesleyan, for example. I know what I would prefer, I would rather pay the associate £900 extra by upping that UDA unit price, as opposed to a potentially bigger liability of anything between the figures I've just mentioned of 42 to 252,000 being the impact of national insurance and potentially backdated contributions. Another potential knock-on effect is, the recent case on the vicarious liability that could also be impacted here, which again puts the onus back on the principal.
Okay, there's some really good ideas then for what they can do to mitigate the risks. Is there anything else that both parties could be thinking about to help reduce this any further?
Definitely. The associate contract needs to be watertight and it needs to include clauses that have been previously omitted. So as I mentioned, the substitution or the locum clause, the lab fee clause, and make sure that both the principal and the associate sit down, and even hygienists and therapists now have a contract that is worked on practically. Imagine, the scene if you've got the HMRC who decides to interview the principal and the associate separately. Will they ultimately be singing from the same hymn sheet? Will their answers be the same, for example? Will the working relationship be deemed as of an employed or a self-employed nature? In summary, these 18 months are going to pass very quickly, and what I would recommend that CESS test be carried out, which you can find on the HMRC website. Sit down, go through your contract and make sure that you can tick some of these self-employed indicators, such as, will you be paying for a locum in the event of your absence? Will you be paying for your own lab fees? Because ultimately one of the self-employed indicators is that if you don't come into work, you don't get paid. A written contract does need to reflect reality, and make sure that you've reviewed and critically, and if necessary, update that contract with the associates. And you should sit down, take your time and review these contracts on an annual basis. That'd be the biggest piece of advice that I would give.
That's really, really helpful. Thank you, Belle. Is this something that we can actually help with for any kind of potential either advice or services that we can kind of help take this risk away?
Yes, certainly. I mean, Wesleyan, we're here to help our dentists, and we're the only financial service providers that I know of who offer locum cover for dentists, which can also be claimed as a business expense. So all I would say is just contact the Wesleyan, contact your financial consultant. Don't hesitate to come to us if you need further information and advice. We're always here to help.
And that's our show for this week. Thank you to Bal and Laura. If you want more information about how Wesleyan can help dentists, go to the website at wesleyan.co.uk. And you can also search for us across Twitter, Facebook, LinkedIn, and even Instagram. You can also subscribe to this podcast at all the usual outlets. But that's it for now. So until next time, thanks for listening.